Welcome to Know Your Rights. I'm sure you have all heard of the term fundamental rights. We all know how these rights are essential for intellectual, moral, and spiritual development of individuals. But most of us do not know what specific fundamental rights are guaranteed by our Constitution and how to secure these freedoms and their limitations, etc. So in this series of Know Your Rights, we are planning to give you a comprehensive overview of fundamental rights and their application. In order to do that, we have with us Mr. Rajeev Amarasuriya, a renowned attorney at law specializing in civil litigation in the appellate courts, including in the area of fundamental rights. He holds a Bachelor of Laws degree from the University of Colombo and also is a fellow member of the Chartered Institute of Management Accountants of the UK. He's also an alumnus of the Harvard Kennedy School Executive Education. So welcome to Know Your Rights.
Nice. It's nice to be here, Rajeevi. Thank you for inviting me.
You're welcome. So to begin with, now we speak about human rights and fundamental rights. So I'd like to know what are human rights?
Basically, every human being, anywhere in the world, when a human being is born, you are born with certain rights. And for example, let us take the right to food, right to clean air, right to education, right to your culture, right to profess a religion. Likewise, those are human rights. And as you know, in 1948, the Universal Declaration of Human Rights was signed in Paris, and they came out with a list of such rights. They put it down, and many of the constitutions thereafter around the world have incorporated several of those rights into fundamental rights, which we will be dealing with a little later on. So to recap, human rights are all rights we as free humans are possessed and are entitled to.
Yeah. So people use these two terms, human rights and fundamental rights, interchangeably. So what are the main differences between the two? How the fundamental rights are different from human rights?
Yes. Fundamental rights are those human rights which have been captured and incorporated in a legal document which is enforceable. Now let us talk from our own Sri Lankan experience. We have a constitution, and it sets out, we have a fundamental rights chapter which identifies certain listed or certain of those rights as being those rights which have been now recognized by the state as being those rights which will be protected, safeguarded and furthered.
So we have a separate chapter on fundamental rights in our Constitution. Yes. So what is the importance of this chapter?
Important in this way. As you know, sovereignty, let's again talk from our own jurisdiction. Sovereignty is in the people, yes, and inalienable. So it's not, sovereignty is not in any office, it's not in the president, the prime minister, ministers, it is in the people. The people exercise the sovereignty in several ways. The legislative power of the people is exercised by members elected by us, the citizens, yes, representatives in parliament, through parliament. The executive power of the people is exercised through the president, who is elected by the people. And the judicial power of the people is also once again exercised by courts, which have jurisdiction through pieces of legislation which have been promulgated by parliament, which also constitutes of representatives elected by us. In addition to that, sovereignty also is enjoyed in two other ways. One is in respect of course, the franchise, the right to vote, but that is how it all starts. And also the Constitution provides that in exercising the sovereignty, all public institutions have a duty to conform to and work within and ensure that the fundamental rights provided in the Constitution are secured and safeguarded and also furthered. So that is how important fundamental rights are, and that is how it becomes a separate chapter in the Constitution.
So what are the fundamental rights enshrined in our Constitution?
Yes. So equality and equal protection of the law, the freedom of thought, conscience and religion, that is the freedom freedom of thought, the freedom to have your views, to express your views, and also the freedom to observe whatever religion one wishes to observe. So that is the first fundamental right. Then the freedom from torture, arbitrary, cruel and inhuman treatment, arbitrary arrest, things like that, which is also an important fundamental right. Then we have the fundamental right of equality and equal protection of the law, which is of course a fundamental right which is used across, in addition to the other rights, we also sometimes bring in Article 12, which we will probably discuss a little later. But the fundamental right to equality and equal protection of the law. Then there are other rights, fundamental right to free speech, to free movement, free association of whatever association, occupation, trade, profession, vocation, to undertake whatever profession, vocation one desires. And of course we have the new right which came in terms of 19th Amendment, that is the freedom the right to information. 14. So that Article 14A, the right to obtain information from public authority. So those are the fundamental rights.
So who can seek protection against a violation of these fundamental rights?
Yes, it is basically in respect of the first few rights which I mentioned, it is any person. So the fundamental right to thought, conscience and religion, torture, freedom from torture, cruel and inhuman degrading treatment, and equality and equal protection of the law. So any person, whether it's a foreigner or even a company located in Sri Lanka has
it doesn't have to be a citizen.
It does not have to be a citizen. It is only in respect of the fundamental rights of speech, assembly, association, occupation. Those rights are limited to a citizen, and also the right to information. The right to information new regime also provides that it has to be a citizen. So that is why when someone makes a request under the right to information regime, you first say that you are a citizen of Sri Lanka.
So what specific groups can be subjected to these violations of fundamental rights when we are enforcing them? Yes.
Now how it works is, in terms of the Constitution, all state organs are duty bound or constitutionally bound to safeguard, protect and further these fundamental rights. So if there is a violation by the term of art used by the Constitution is executive and administrative action. So in layperson's terms, that would be basically action by the state. So if there is a violation of any of these fundamental rights by the state or any person or entity which is acting under the color of office of the state, then that would amount to a violation of fundamental rights. So if say all of us as citizens have dealings with the state, so if the state violates any of these fundamental rights which we set out earlier, any of those against a citizen or a person, then there is a violation which can be enforced in terms of the Constitution. Or one can go before the Supreme Court and seek to have some reparation or have some relief granted in respect to the violation.
Okay, so this also includes not only an infringement but also an imminent infringement. So what does it mean?
Yes. Now, before we come to the difference between infringement and imminent infringement, there is also a time period within which you have to come before the court. Now, at this point, let us pause a little bit. Now, one course of action is, of course, to go to the Supreme Court in terms of Article 126 of the Constitution. That is, the Constitution provides that if there's infringement of fundamental rights, then one must make a complaint to the Supreme Court within a period of 1 month from the alleged infringement. Yeah. Now, you ask the question, what about imminent infringement? Now, imminent infringement means that there are two types. One is if there is a violation taking place, there is some act which was perpetrated which amounts to a violation of your fundamental rights. Something happened. Say for example, some decision was made, or some right of yours was taken away. You were unlawfully arrested. So that act took place. So that is a violation. Imminent violation is something is going to happen. You have intimation notice that something is about to happen and which will have an effect of violating your fundamental rights. So that is what you mean by imminent infringement. So you don't need to wait till the act actually happens. If you can establish before the court of law that, or the Supreme Court, that this infringement of your rights is now going to, it is nearly certain or certain that it will happen today, tomorrow, in a week's time, then at that point also you can go to court and say, well, there is an imminent infringement of my fundamental rights, it's about to happen. For this reason, the decisions have been made, it's in the course of happening, I am coming before court before it happens. So sometimes it's, if you have that opportunity, you must go at that point, because so it's so much practical. Because before the act happens, you can try to stop it or have it suspended. Now, when I said I've got to pause a bit, is that there are, now if there's a violation, you can go to the Supreme Court, but also we have the Human Rights Commission. The Human Rights Commission is also established by an Act of Parliament, and if there's a violation of your fundamental rights, you can also invoke the jurisdiction of the Human Rights Commission. Now, the difference being between the Human Rights Commission and the court, of course, is that the court, when it makes a pronouncement, it's in the form of a judgment. Right. So judgment is something which you have to comply with. Now, to some extent, the problem, I can say, in the Human Rights Commission is that it is only recommendations which can be made by the Human Rights Commission. Of course, there are a number of circulars by the state, by the public service and the government, successive governments, saying you must conform and implement Human Rights Commission recommendations. However, the fact remains that it's a recommendation as opposed to a judgment, and I think maybe when there's law reform, one must look at maybe giving more teeth to the Human Rights Commission to enforce their decisions as well.
So you also mentioned about the time limit of 1 month. So what's the importance of this time limit?
It is important. It's basically a constitutionally imposed time bar. As you know, in any type of litigation, there is a period within which you have to invoke or you have to exercise your rights. And there is this concept of law saying you can't sleep over your rights. So the Constitution prescribes that if there is a violation of fundamental rights, you have to go to the court, if it's a Supreme Court, within a period of 1 month. Now, some might say, why such a short period of time? Because sometimes it takes time to, if there's a violation, you have to get advice, legal advice, go and draft paper. But the flip side of that is that if you provide a longer period of time also, then of course you have the problem of those decisions. There is no certainty, say a government institution, because now the presumption must be that when the state is acting, they are acting correctly. The presumption can't be that they are unlawfully or illegally acting. So we all presume that the state will do the right thing. So if you are challenging it, then the period is 1 month, because those decisions, otherwise if you give a longer period of time, then there's uncertainty, you don't know whether it will be challenged, you don't know whether you can take it forward. So that is why they have probably thought, they have given a period of 1 month. Of course, there are several other jurisdictions around the world where even there is no limited period like this also, where you can challenge action at any time. So there are those other jurisdictions. But we have a period of 1 month.
So are there any instances when the court has actually departed from this limitation of 1 month period?
No, it's not a question of departing from the limitation of 1 month, but there is this concept called continuing violation. Now, we spoke of imminent violation at the beginning, then we said violation and continuing violation. Continuing violation is where, say your fundamental right continues to be violated. There is an act which is perpetrated at a given point of time, but that there's continued perpetration of that act continuously. So in those circumstances, the court has intervened and said, well, no, it's a continuing violation, and the petitioner also can.
Could you please give an example?
There are several. There are often now, for example, say arrest. Say if you have been arrested, and if you're continuing to be in detention, then there's continuing violation.
Yes.
Your rights have been taken away. So there's a point of arrest, but then you're still in detention.
Yes.
So that's one example. Then also there is this concept of the public trust doctrine.
Yes.
Now the courts have invoked the public trust, where the principle is that state officers, the state holds office in trust for the public. So there have been instances where the courts have like you mentioned, gone beyond the 1 month and said, well, this has violated the public trust. Now, good example is the Water's Edge case,
Yes.
where the court several years later found that the approval process, there were problems in the approval process, there were problems in those, the grant of whatever concession given to the developer, and several years down the line, they reversed that transaction. The same with Sri Lanka Insurance, where the privatization of Sri Lanka Insurance was reversed several years down the line, invoking this public trust doctrine.
Yes, so we will speak more about public trust doctrine in a later session. So if one wants to actually file a case, a fundamental rights case, so what is the procedure, what's the correct procedure?
Yes. Now, say let us take an example now, run-of-the-mill case, say you're a public servant, yes, and say you're denied a promotion. Simple case, you have all the qualifications, you have the eligibility, you believe that you have the highest marks, but for some reason someone else was appointed. So you have to invoke the jurisdiction of Supreme Court by way of a petition affidavit. Setting out, it has to be within 1 month. The case has to be filed within 1 month of that date you get to know that you are not promoted. Setting out your grievance, setting out the violation of your rights, and then basically you invoke the jurisdiction of Supreme Court. It's not like a civil matter where sometimes you file a civil case and basically the case is accepted and you proceed. This in fundamental rights you have to go and obtain leave to proceed from the court. So which means that you have to give, usually you provide notice, and other parties come. The Attorney General will be, in all fundamental rights cases, you need to make the Attorney General a party. So whether the Attorney General is retained by the other respondents or not, the Attorney General will be a respondent, and you have to support the case for leave to proceed, which means you have to satisfy the court that there is a prima facie case of a violation, alleged violation of your fundamental rights, and the court must be satisfied that there is a prima facie violation, and then the court would grant you leave to proceed, which means the court will accept your case for further hearing. And then of course there is a process of the other side filing objections and the petitioner filing a response, and the matter will be taken for hearing thereafter and a judgment pronounced.
So you spoke about prima facie. What does it mean, the term?
Basically, it must be a case, on the face of the case which is being presented, there must appear to be to a reasonable person or to the court a case of a possible infringement. Now they must on the face of the document see, well, this appears to have happened. I mean, not conclusively, because you have to hear all parties, have documents filed, but it must appear to the court that there is, now sometimes we say, it's difficult to relate to a burden of proof, but basically the court must be satisfied that there is a fit and proper matter for the invocation of the jurisdiction, and for the court to be possessed of it, and for the court to take on the case. So the judges sitting must so the job of the attorney is to convince the court, well, there is a violation, we can show it, and basically this matter must be taken on.
So now, with respect to all other matters, we have the original jurisdiction with the other courts, but with regards to fundamental rights, the sole jurisdiction is with the Supreme Court. Now, is this fair to people because you don't have the opportunity to appeal?
Yes, I mean, one could look at it from that aspect. Anyway, when the drafters of the Constitution, when they drafted it, have thought it fit to place the fundamental rights jurisdiction with the apex court, the Supreme Court. So when the Supreme Court makes a decision, of course there is no appeal therefrom. Well, it has its positives and negatives also, because as you know, all other types of cases we file, we go to original court, and sometimes you have one appeal, sometimes you have two appeals, and different stages of review. However, here you go to the highest court, the apex court, and the court reviews it. Probably the thinking was, when they drafted the Constitution, was that when you file a case, you're complaining of a violation by the state, and it is probably a good thing for the highest court of the land to consider this violation and make a determination. That is one. Then also you don't want several stages of appeal, which means that it delays the whole process, and you need some finality. In fact, the Constitution provides that a fundamental rights case should be heard and disposed of within a period of two months. Now, given the workload of the courts, it's practically impossible, and it has, I mean, over the years the courts have acknowledged that fact. But that was the thinking when the Constitution was drafted. But like you said, it is always good to have a second opportunity to review a matter. So that is, of course, that is not available. Now, I know in several other jurisdictions, I think even in India, you can take up issues of fundamental rights even at the High Court level. So maybe when with law reform, that is one thing also which can be considered. Because as you know, the writ jurisdiction is in the Court of Appeal. So the Court of Appeal exercises the writ jurisdiction, and where necessary, the Supreme Court reviews it. So that may be something to look, going forward. But for the moment, it is placed with the apex court.
So what's the final piece of advice we can give to our listeners on fundamental rights jurisdiction?
So one is like the title of your program, you must know your rights. Yes. To begin with, you have to know that you have these rights. From practical experience, one problem I have seen is that sometimes there are litigants or clients who don't realize that if you are invoking the fundamental rights jurisdiction, you need to come within 1 month of the infringement. Now, sometimes there is obviously practically, not everyone wants to go to court, and I fully appreciate and understand that. But if you are going to invoke the jurisdiction of the court, then you must come within 1 month. Sometimes you have opportunity of writing letters, making representations, seeking meetings. All that is well and good, but the problem is if you embark upon that administrative process and then you want to come to court later, the court will turn, court on the other side, your respondents will say, well, there is a time bar of 1 month, you should have come within 1 month. And there are several judgments say, if you go through this process of administrative relief, then you must go through that process. You can't pick and choose which course to, you have to elect. And you can't, go down one avenue and then change and come down another. Just one other thing I wanted to add, which I think we missed, is that if there's a violation of a fundamental rights, and say you go within that 1 month to the Human Rights Commission, and you make a complaint there, then the period of this time bar stops running. So there is relief there, so that you can always go to the Human Rights Commission and then you can invoke the jurisdiction there. And then once the outcome or once the recommendation is made, you still can come back to Supreme Court, provided that the period of still 1 month is in operation.
Well, that was very insightful. I hope to continue this discussion in our next episode. And thank you very much.
Thanks, Rajeev. It was nice to be on your program.
So, dear friends, we hope you learned the basics of fundamental rights from this discussion. In the next episode, we hope to discuss these fundamental rights in detail. Therefore, I would like to invite you to like this page as well as our YouTube channel to receive the latest updates. Also, if you have any questions related to this area, please write to us at help@knowyourrights.lk or send us a Facebook message. We are bound to protect your privacy and confidentiality. We hope you will make the most of this opportunity. I'm Rajeevi Mapalagama. Thanks for joining with us today.
For more information, visit us at www.knowyourrights.lk or visit our Facebook page, Know Your Rights SL, or email us at help@knowyourrights.lk.